All rise. The Court of Appeals, First Appellate District of Ohio, the Honorable Pierre Bergeron presiding, is now in session. Please be seated.
Good morning, everybody. Welcome to the First District Court of Appeals. We have two cases to be argued today. When I call the case, if counsel could identify themselves and indicate their readiness to proceed. First case is City of Cincinnati versus P.E. Alms Hill Realty.
Good morning, Dan Fleming for appellant.
Okay.
Stephen Rothstein, co-counsel.
Okay.
Good morning, Terry Posey for U.S. Bank and Wilmington.
Okay. Thank you. And then the next case is State of Ohio versus Robertson.
Good morning, Michelle Berry on behalf of the appellant, Tierra Robertson.
Morning.
Good morning, Your Honor. Keith Stoddard for the appellant.
Morning. Okay. Each case will have 15 minutes per side. I'll have the light system. Green means go, yellow means you have a minute left, and red means you're at your time. Mr. Coleman? Would you like to reserve any time for rebuttal today?
I'm sorry?
Would you like to reserve any time for
I would
rebuttal?
like to reserve 5 minutes.
Okay. You may proceed when you're ready.
May it please the court, I'd like to focus on three issues for oral argument today. And those are, first, the failure of the trial court to rule on Mr. Pertz's objections to the magistrate's decision in violation of Civil Rule 53D4D. Secondly, the due process violation of the trial court's sua sponte summary judgment order that was entered while the parties were in the middle of a damages hearing. And then third, I'd like to address today the failure of the lenders to meet the foundational requirements of 803 Evidence Rule 8036, the business records exception to the hearsay rule, and also the adoptive admission exception that they were relying on to further rely on the business records exception. And the relief that Mr. Pertz is requesting from this court is that this court vacate the trial judge's judgment that was entered and require the trial court to rule on the magistrate's decisions as required by Civil Rule 53D4D and allow the damages.
Is that argument in your opening brief or just in your reply?
I'm sorry?
Is that argument in your opening brief or just in your reply?
I think it's in our response. Yes.
And so is it waived or is it properly before us?
Well, we had addressed in the opening brief the failure of the court to rule on Mr. Pertz's objections to the magistrate's decision. So I do not think it was waived. And since it's a fundamental jurisdictional issue, I don't think it can be waived. And I'd like to elaborate a little further now on the issue of Civil Rule 53D4D. What happened in this case was we were in the middle of a damages hearing that Judge Baradon had referred to the magistrate. He had denied summary judgment on the issue of damages and referred the damages issue for an evidentiary hearing with the magistrate. And the parties began a damages hearing in front of the magistrate. And during that hearing, there was an objection to the custodian of records that the lenders were relying on, who were trying to establish the business records exception. And the magistrate decided that briefing was needed. She suspended the damages hearing. And so the parties briefed the issue. Ultimately, a magistrate's decision was entered. And then once it was entered, Mr. Pertz timely filed an objection to that decision. And during that time, the magistrate adjourned and continued that damages hearing, awaiting the decision of the trial court on the objections to the magistrate's decision. But no decision, no ruling on the objections ever came forward. Instead,
Well, but that's because the trial court ultimately granted summary judgment.
That's right.
Doesn't that moot these objections?
I don't think it does. There's case law.
Because the objections were talking about what's happening on the damages hearing, and the trial court is taking a step back and saying, shouldn't have even got to the damages hearing because summary judgment should have been granted.
Yes, the court said summary judgment should have been granted. The summary judgment decision doesn't say anything about the issue of the business records, doesn't address it at all, just says summary judgment is granted for the lenders for, you add it all up, over $32 million. And so the issue on Civil Rule 53 D4D, does it moot it? That rule doesn't say it's mooted. That rule says the court has to make a ruling. It says the court shall rule on the objections. And there are cases out of the 9th District, Young versus Young, Henry Strickler, and Wagant versus Porterfield that have addressed this, where they said even when it's not specific enough on the ruling on the objections, even when there's been a reference that maybe the objection should be overruled and the trial court has said that in a journal entry, that's not enough. Here, there was no indication at all that the trial court ruled on the objections. So fundamentally,
And I want to go back to Judge Kingsley's question, because I'm going through your brief and I don't see anything in here about Rule 53. Am I missing it?
Yes, as Judge Kinsley asked me, and I noted to her, the reference to 53 D4D was made in the reply brief.
Well, I mean, typically we don't consider arguments that are raised for the first time in the reply brief because it disadvantages the appellee who doesn't have a chance to address those.
Yes, and I understand that, but it was not a new argument that we were asserting. It was in response to an argument raised by the lenders that the failure of the court to object to rule on the objections was something that one court has said you can assume was overruled. And they relied on one case out of the 9th District that said you can assume that the objections were overruled. And out of that district, subsequent cases said that's not the case. So we were replying to that argument from the lenders that you can't just assume that the objections were overruled because 53 D4D says otherwise. And these cases, after the case they cited, show otherwise as well, that you have to specifically rule on the objections. So I understand the court's concern about raising a new argument. We were not trying to do that. We were instead addressing what the lenders brought up in their opposition brief. And also it happens to be a jurisdictional issue. So
Can you address that more? What do you mean by a jurisdictional issue? Do you mean that we don't have jurisdiction over your appeal?
Well, yes, there are these cases out of the 9th District say that if there is a failure to specifically rule on the objections on a magistrate's decision, there's no final judgment yet. And if there's no final judgment, there's no final appealable order that the Court of Appeals can hear.
Well, why did you appeal if there's no final appealable order?
Well, because they took the position they did have a final appealable order. They have actually domesticated their judgment in New York already. And the trial court said it was a final appealable order. So that's why we took this appeal. And I think what needs to be done is to make sure everybody, the lender and also the court, understand and know that there is no final judgment in this case because 53 D4D has not been complied with. And so that's really the point. And there was no effort whatsoever to try to raise this for the first time in reply. It was simply to respond to an argument asserted by the lenders. Connected to that, I'd like to address the due process issue.
Yeah, and I have a hard time understanding the due process issue because, and so help me out here, but typically a summary judgment decision is interlocutory in nature, which means that the court can revisit that either on its own initiative or the party's initiative at any point before it enters final judgment. So here, it seems to me that's what the trial court did, and so I don't understand how that's a due process issue because you got to brief everything during the initial briefing on the motion. It just turns out the court granted it at a much later date. So where is the due process violation?
The problem here is that what the judge did was entered a sua sponte decision contrary to what prior trial courts had told the parties to do.
But that's the trial court's prerogative. The trial court can do that.
On notice, they can always do that.
But why? So that's my question. Why do they have to give notice that they are changing, that the court is changing its mind?
Because in any time you have a motion for summary judgment, the sine qua non of a Rule 56 motion for summary judgment is always notice. And there was no pending motion at the time the court...
But the reason for notice is to give the non-moving party the ability to raise arguments and evidence to show there's a genuine issue of disputed fact. You already had that opportunity in opposing the initial motion. So, how does the lack of notice prejudice you?
There's nothing that we can tell in her decision, the trial court's decision, that indicates how she came to her reconsideration, why she reconsidered. And so Mr. Peretz had a procedural due process right to be on notice about the reason why she was reconsidering so he could marshal any evidence he had to rebut that. And he was deprived of that. And that's the procedural due process violation at stake here.
Wasn't his response to the summary judgment evidence and the summary judgment motion itself his procedural due process? Why was that not sufficient?
I'm sorry, could you repeat that again, Judge?
Sure. I mean, when the summary judgment motion and Solomon's affidavit and the exhibits were filed, Mr. Peretz had the opportunity to respond to that. Why was that not his procedural due process?
Because what the trial court did was stated in her sua sponte order that she was reconsidering without providing any notice as to why she was reconsidering. And so he had a procedural due process right to come forward with whatever evidence he had on a reason she didn't give in her order as to why she reconsidered, as to why she should not sua sponte enter judgment. And I think he would have been justified in doing that because he had every reason to believe that what happened here was the court said there had to be a damages hearing, and there was in fact a damages hearing that was ongoing. And he had the rug pulled out from under him without notice and without knowing why it happened. All we know is that the judge said, I'm doing it sua sponte, and we don't question that a court has the right to sua sponte change interlocutory orders. That's not the issue.
When parties ask for more due process, there's a test for that, the Matthews factors that we're supposed to look at to consider whether a person is entitled to more process. Have you considered those factors or how we should apply the constitutional due process test?
No, I haven't considered that, Judge, but what I have looked at is that this was a situation where no notice was given about a reason why this was happening. If you look at the judge's order, it doesn't indicate anything other than a recitation of there were these summary judgment orders entered in the case, and and then, therefore, I'm reconsidering. And then $32 million judgment is entered. That's it. That's what the order says. It doesn't indicate at all what happened and why it happened. And I'm not,
Mr. Fleming, I hate to interrupt you, but you're past your time if you want to, and that's because of our questions, but I'll let you go a little further.
Okay.
If you want to reserve 5, this is probably a
Okay.
good stopping point.
All right, thank you.
All right, thank you. Mr. Posey, good morning.
Morning. May it please the court, Terry Posey here for Appalese U.S. Bank, Wilmington Trust, by and through the special servicer L&R Partners. It sounds from the opening argument that the court's very familiar with the issues, and I'll try to keep hitting the high points. Addressing the issues in the order stated by the appellant, failure to issue a ruling on the objections to the magistrate's decision sort of calls into question what the temporal state of things are at the time that reconsideration was ordered. Judge Bergeron acknowledged that the court reconsidered a fully briefed summary judgment motion from a year and a half, 2 years beforehand. Everything that had happened since then with regards to holding a hearing, having a magistrate's decision filed, objections to that decision filed were obviated because the court jumped back in time to reconsider a fully briefed summary judgment decision. And as my co-counsel or opposing counsel has indicated, courts can reconsider decisions at any time. The issue from both the Rule 53 and the due process segment was Mr. Peretz entitled to any notice that was going to happen. And there's no case law cited in their briefing that suggests the requirement that there would be any notice. The cases that they cite are cases in which a court, first of all, sua sponte, entered a motion of judgment on the pleadings without notifying the parties at all that it was thinking about doing so. And the second one was where it used evidence presented in front of a not fully briefed second summary judgment motion to grant the first summary judgment motion. That's not the circumstance here. The court here, as it was entitled to do, revisited the summary judgment briefing, and there was quite a bit of summary judgment briefing, and decided that both liability and damages were established.
Was there any objection during the summary judgment briefing to the admissibility of the testimony of, I forget the name of the witness?
Yes, Ms. Solomon's affidavit was challenged in opposition to the summary judgment briefing, the same as it was at the evidentiary hearing. The issue was raised and presented in nearly the same format.
Mr. Posey, let me ask you, this is my recollection of the briefing. The matter was referred for the damages hearing. Was that done by a prior judge, and the summary judgment was granted by a judge, a subsequent judge?
Yes, Your Honor.
So is it your argument that the new judge revisited the summary judgment?
Yes, and again, it's uncontroverted that interlocutory decisions may be reconsidered until a judgment goes final. The new judge came in after the objections to the magistrate's decision were issued on some of the evidentiary issues. The ruling, new judge came in after that was fully briefed, revisited the summary judgment motion originally, and issued an order granting summary judgment in full as opposed to just on liability.
Okay. And so what is your position on whether there's a final appealable order here? Because even if they have waived that in terms of a substantive argument by not raising their opening brief, if it is a jurisdictional question, we are not only entitled but obliged to consider it.
With respect, that's sort of the argument I was making when I opened, is that the court eliminated all of the subsequent proceedings by revisiting back to the date of the fully briefed summary judgment decision. The objections to the magistrate's decision were premised on a hearing that has been obviated by the summary judgment's decision, and so there is no objections to the magistrate's decision once the summary judgment itself is reconsidered. I think it would be, and again, there's no case law cited on this specific issue other than generally pending objections to the magistrate's decision must be explicitly referenced, but none of those cases reference a circumstance in which the judgment that's ultimately entered was a previously filed summary judgment, fully briefed summary judgment decision. So I think the court would be elevating form over substance, requiring a ruling on an objections to a magistrate's decision that the current judge doesn't believe the evidentiary hearing is required for.
So in other words, your position would be that if in the words that I used earlier, the issue is rendered moot there is no obligation under Rule 53 for the court to actually rule on those objections.
I actually think that's what the trial court did by entering summary judgment, mooted the subsequent proceedings by virtue of finding that summary judgment was appropriate on liability and damages. And just to talk a little bit about the due process violation again, Mr. Puretz does not point to any place in the record where he was denied an opportunity to submit his own evidence in opposition to summary judgment. Due process only requires notice and an opportunity to be heard. The specific issue he's complaining about is not getting to cross-examine the affiant. But it's worth noting again, prior to the trial court's decision, the initial decision granting judgment on liability only, there were no efforts to cross-examine the affiant, no efforts to depose an affiant, no Rule 56F motion saying that they needed discovery from the affiant to make any conclusion or any opposition to their summary judgment motion. They're claiming now that they did not get the opportunity to cross-examine her in a live hearing, but that was not an opportunity they sought before the briefing was closed on the summary judgment decision.
Counsel, how did they respond to the Solomon affidavit and exhibits?
Through their 8036 motion, that the documents that she's attempting to incorporate through her affidavit were insufficient, and the affidavit was therefore not appropriate for summary judgment. They made that argument on the paper, which is part of why I think the original trial court set the matter for damages in a live hearing instead. I would like to talk a little bit about the 8036 business records and adoptive records exception. This is not an affidavit that would have been challenged or should have been challenged or is appropriate for being challenged. This was a highly detailed affidavit. Ms. Solomon put quite a bit of information about her relationship between the loans at issue, her role at L&R, and her L&R's use of the business records here to satisfy 8036. 8036 has 4 requirements. The records must have been recorded in a regularly conducted activity, must have been entered with a person with knowledge of the fact of intercondition, must have been recorded at or time of the transaction, and the foundation must be laid by the custodian of the record or some other qualified witness. In short, the 8036 business records exception is asking, does this business rely on these records? And Ms. Solomon testified clearly of error to that in her affidavit. She testified that L&R is a special servicer of the loans, that she's been an asset manager for L&R and has personal knowledge of L&R's record-keeping system. She'd been there since 2004. She was assigned to the asset manager for these specific loans after the transfer from the master servicer.
So I understand like the practical realities in when companies acquire other companies, and then you have the person who actually was there at the time the records were created is no longer there, and you have to rely on testimony like this. But if one of the kind of requirements in the business records that you just articulated is that it has to be made at or near the time of the transaction, the person coming in really has no knowledge of that. And she can say, as you just articulated, well, we rely on these, but just because you rely on those, how do we know that they're reliable?
So there's 2 lines of case law that sort of address this question. And the first one says, are there any indicia of unreliability, or is there just an indicia of reliability? Again, this is a highly detailed affidavit with regards to the transaction components that result in these being the records relied on by L&R. And then I would point to the inverse of this, and the second line of reasoning is that all that's required for a Rule 56 movement is to put forth that there is no genuine issue of material fact, and it falls to the opponent to then show that a genuine issue of material fact exists. No fact put forth by Ms. Solomon was affirmatively contested by Mr. Puretz.
So in other words, you would say, coming in and saying, like, I didn't sign that document, or the signatory did not have authority to sign that document or something like that.
Or the amount's wrong, because I have a payment record that shows that I made $10 million more worth of payments than they're including. And there's case law on whether those affidavits can be self-serving or need some line of documentation. But 56 motions are designed to be an oppositional process to where the truth is derived from the submission of competing materials, not solely the attack on the viability of the materials. Mm-hmm. There is case law in Ohio that says that affidavit's too short. You didn't tell us how you got here, and you just said that this was the amount due and that these are the documents. That's not Ms. Solomon's affidavit. It's very detailed, very long, and details her relationship with these particular loans and her role at L&R. And in fact, again, the primary case cited by Mr. Puritz is Ohio Receivables versus Williams. That was a debt collection case, and then the second district immediately backed away from it, and Ocwen Loan Servicing versus Malish, really saying that as long as, again, there's no indicia that these documents aren't what they say they are, you're comfortable relying on them from an adoptive business records exception. There were some other arguments in the Mr. Puritz's brief regarding the ambiguity of the loan documents. I believe those are fully explained in the briefing. The ambiguity, he's claiming that compulsory counterclaims are allowed, but defenses aren't. It's sort of a red herring. There were no compulsory counterclaims raised in this litigation. The purpose of a non-recourse loan like this that carves out springing recourse exceptions is to facilitate, in the event of default, the mortgagor's recovery of the value of the asset. Defense of the litigation is clearly stated. There's nothing in the paragraph cited about compulsory counterclaims regarding maintaining a defense of the litigation is allowed. Compulsory counterclaims would have to be allowed, or you'd not have the ability to bring them. And then again, with regards to enforceability, unconscionability, that was waived in the contractual documents, waived by not filing it in the answer. And again, these loan documents were between sophisticated commercial parties, all represented by counsel, and there's no case law in which a similar set of documents would ever found to be unconscionable when everybody comes to the table with equal bargaining power in a commercial context. Having said all that, we would respectfully ask that the decision of the trial court be affirmed.
Okay, thank you. All right, Mr. Fleming, you have 5 minutes.
I'd like to address the issue raised on 8036, the business records exception to the hearsay rule. The problem with Ms. Solomon's efforts to appear as a custodian of records and bring documents and records in as under the business records exception is she only focused on how L&R relies on these documents. But these documents were not created by L&R. And what a witness like that has to do is, first of all, they have to have a personal knowledge. They have to be able to testify that the third-party preparers, the documents of the third-party preparers are business records. So what the case law says is what you have to do there is you have to show that you know that there are systems. You understand how their systems work for maintaining business records and why they maintain those business records. So we received no information in her affidavits or her testimony about that. Ms. Solomon does not have any evidence to establish that these are the business records of the parties that prepared those documents. So you can't just get a head start by saying, well, I'm relying on the adoptive business records exception because we, L&R, are relying on the documents.
Well, if 8036 subsumes the business records requirements for the business that originated the records, how would an adoptive business ever be able to prove that?
They can easily do that if they have a competent witness who can explain, here's how they keep their records.
What if the originating business went out of business?
I'm sure there's a way. I mean, I don't know.
But that happens all the time, and there's a practical ramification of, my concern is you're trying to set the bar too high, and then in these scenarios where the business goes out of business, where the records custodian dies or, runs away to Florida or something, there's no way to ever get those documents admitted.
Well,
and maybe your answer would be there's just no way to do that, and that's their problem.
This 8036 is the rule. There's an evidence rule on this that cannot be skirted, and you can't use as an excuse, well, I'm sorry, the business went out of business. There is probably a way to find out how they can use subpoenas to get information on how the business operated. They just need some knowledge to be able to say, here's how they kept their records. There is nothing here. And we know that these records here are not records of a company that went out of business. They're existing. And not only that, the special servicer L&R could have easily reached out to their own client and say, how do you keep your records?
Do we have any reason to doubt the authenticity or accuracy of these records in this case? Can you address your opponent's point about the dispute of material fact issue?
It's not Mr. Pertz's burden to come forward with evidence on 8036 and meeting the foundational requirements of 8036. The proponent of the evidence is the one who has to come forward and meet the foundational requirements. Mr. Pertz is not required to come forward with his own evidence to show why he doubts those records. It's a foundational requirement. It's an evidence rule required to be met by the proponent, and it wasn't met here. And not only that, the adoptive business exception record doctrine talks about how these documents have to be relied upon the company who adopted them. Now, that's where Ohio Receivables versus Williams comes in, all right? That's cited in our brief, where we talked about that, where we said not only did they not meet the foundational requirements of 8036, but they don't meet the foundational requirements of the adoptive business doctrine, because under Williams, you have to show you actually used it for your business. And in Williams, it was a debt collector who was simply seeking to introduce the records. And the court found that's not evidence that it's part of your business. Same here. L&R is only brought in when there's a default, when there's an allegation of a default, and they're trying to collect, which is what they're doing here. And so that's why we're relying on Williams, because they also fail to meet, under Williams, the adoptive business records doctrine. And
Mr. Fleming, you are at your time now.
I'm sorry?
You are at your time now.
Oh, okay. Thank you.
All right. Thank you both for your arguments this morning. The case will be submitted, and we'll get out a timely written decision. Hope you all have a great day.
Thank you.
Thank you. Okay, the next case is State versus Robertson. Just take your time, counsel, whenever you're ready. Morning, Ms. Berry.
Good morning, Your Honors. May it please the Court. Michelle Berry on behalf of the appellant Tiara Robertson.
Would you like to reserve any time for rebuttal?
I'd like to reserve 3 minutes.
Okay. You may proceed.
May it please the Court. Your Honors, this self-defense case is one that turns completely on jury instructions that were missing crucial language on multiple points that ultimately undermined confidence in the verdict. Now, I wanted to have this argument so that I could be a bit more blunt than I could be in the written brief, and also to address things in a different order than it really made sense to in the brief, where you kind of need things chronological to tell the story. So today, while I believe the most egregious and pervasive error in the jury instructions is the failure to instruct on the presumption of self-defense, that Tiara acted under the presumption of self-defense under these circumstances, I'm going to actually first start with the instruction's failure to define the word residence and dwelling, because that's a very kind of short and sweet argument that really ends the case on standing alone, set aside all the other errors. So addressing that error first, defense of residence was given as an option for Tiara to have acted under, but the instructions crucially failed to define what residence and dwelling means. And that's very important here for obvious reasons. Without having those terms defined, the jurors very likely are thinking of the colloquial definition of defense of residence, meaning the actual four walls of the house. But under Ohio self-defense law, that is not what residence means. Residence under the statute 2901.05 D2 and D3 actually includes a covered conveyance as well. And in the statute actually uses the term attached porch. And that's universally accepted in the case law as well to mean exactly that, as well as areas exactly like this, which are akin, like a covered carport that we're talking about here. All of the gunfire happened under this covered carport. Tierra was under the covered carport and Anisha was under the covered carport. And under Ohio law, that counts as part of the residence. So here you have jurors taking this case under consideration, and they're thinking house. They're thinking, well, she wasn't inside the house. How can she possibly be defending her residence? And they, I'm sure, threw that option out the window. Had they had those terms defined, it could have been, they very well likely could have adopted her theory of defense.
Ms. Berry, my understanding is the court had agreed to give that instruction, failed to do so. Is that correct?
Correct, yeah. And in fact, the court did give the defense of residence instruction, just didn't define the terms.
Okay.
And one of the things that's very important.
Wait,
yeah.
I'm sorry.
Yeah.
Maybe I'm confused here. I thought that the argument was that they did not, that the court said it would give the instruction, but then did not give the instruction.
Well, that is true for the presumption of
The
self-defense.
presumption, okay.
And I will move to that very soon here because it's
Okay.
very related.
Okay.
But one quick point I want to make with just the instructions missing the actual definition of residence is that, I'm standing here saying it's obvious the jurors would need that instruction to even give meaning to what defense of residence means, but the police officer that's investigating this case, as well as the prosecutor, were also messed up about what residence meant. They also thought it meant the four walls of the house. So if you have the police officer who's actually investigating and enforcing the law, and the prosecutor who's literally at trial for this case, not knowing what residence means for purposes of self-defense, clearly your jurors are not going to know what residence means.
Well, I guess my question is there case law that says that those terms have to be defined?
Yeah,
Okay.
I think under the constitutional standards as well, jurors need to be given full and complete instructions, and that's under the federal constitutional standards and state.
Yeah, well, right, but I mean, at some level, like, we don't have to define every single term in a jury instruction, or else, like, those would go on for,
Correct.
they would put all the jurors to sleep. So my question is specifically to the terms of residence and dwelling. Is there authority that says these terms are ambiguous and they need to be defined?
I don't know of any specific case that touches on that very narrow specific point, but I think those overriding constitutional principles, when considered here, it's the heart of the actual defense. Defense of residence is a theory in and of itself. You have self-defense, defense of another, defense of residence. They all three were at play here. And when you don't have the term residence defined, and it actually has a specified meaning outside of what the colloquial understanding is, you absolutely would have to have that defined. And that's exactly what the situation is here, which, again, it's very telling that the state's two principal players here, the law enforcement officer and the prosecutor, had misconceptions as to what that term meant.
Wasn't this a contested issue in the case, and the trial court made a finding, a legal finding, that the covered porch area was the residence?
Yes, that's absolutely correct. And that actually moves me on to the next, I would call the most egregious error, which is the failure to instruct about the presumption of self-defense. And correct, in the transcript at 738 to 740, there's a lengthy discussion about this point. And the court does find exactly that this covered carport area is akin to the attached porch that the statute talks about and that the case law universally speaks to as being part of the residence. And for that, and also finds that the entirety of the affray took place in this area and that is part of the residence. All of these findings occurred in that portion of the transcript. And the court had stated, yes, I am going to instruct on the presumption of self-defense.
So the court says, I'm going to instruct on that. And everybody's like, okay, great.
Yeah.
And then the court doesn't.
Does not do it.
But there's no objection at that point by defense counsel. And so one of the questions I had was preservation. Clearly, they advocated for and were granted the instruction on the front end, but then when it doesn't get read on the back end, like what happens?
Yeah, so I think there's two ways to look at it. There's a case, State v. Wallens, that addresses this scenario and says when defense asks for the instruction and is given the proper law, when you don't object, the error actually still is preserved. So we would take the position that this actually is an abuse of discretion scenario. But even if the court finds that there should have been an objection needed to preserve it, this is clearly a plain error. And also, we do have that covered under ineffective assistance of counsel. But just speaking to the plain error, the failure to give this instruction really is, it's fatal. There's no way to overcome this. It completely takes away one of the state's burdens, and it completely changes the jurors' starting point thoughts about the case. So one of the most important things is the state was hammering home that Tierra created the danger here. Tierra created the violence. Well, this instruction would not only give the burden to the state to rebut the presumption that she actually acted properly and lawfully, but it addresses that you're presumed to have acted in self-defense when using deadly force that's intended or likely to cause death. And I think one of the more contested points may have been, was the use of force reasonable? Was it at a level that was appropriate for what the situation was? And that's, there's the obvious reasons why this instruction is important, but then when you think about these detailed aspects of the use of force that was used, gunfire was used, this presumption of self-defense speaks to that use of force, and the jurors didn't have that starting point. If they had, they would have been thinking, I'm presuming that Tierra acted lawfully. I'm presuming that she had a bona fide belief that she was in danger.
And then the state can overcome that by just a preponderance, right?
Correct.
Okay.
Yeah. And they would have assumed that the level of force was also proper and lawful. So those would have been their starting points. But without instruction on that, they didn't have that. They were already thinking she committed this felonious assault. We've already reached the guilt part. And they didn't have that extra burden that the statute has actually put on the state under B2 of 2901.05. And that's, there's the second district case that I really rely on extensively in the brief, State v. Jones. That's a very helpful case because it's a very similar situation. The presumption of self-defense was omitted there as well. And the court gives a lengthy explanation of why this is different than just stating, like here, the jurors were given the instruction that the state had to disprove that Tierra acted in self-defense. But this is an additional burden put on the state, and that State v. Jones case does a great job of distinguishing why it's an additional burden and the distinction between B1 and B2 of 2901.05. So that's a helpful one to come back to.
Ms. Berry,
yes.
Under self-defense, if it's defense of residence or under the Castle Doctrine, my understanding is there's no duty to retreat as well. Is that correct?
That's exactly right. Yeah, there's no duty to retreat, and that actually was properly instructed on.
All right.
And I think, given that it all was settled that the presumption of self-defense was going to be included, it seems that there was sort of a conflation between what Castle Doctrine means now and what it used to mean. Now there's no duty to retreat if you're lawfully occupying any space. It used to just refer to the home, the residence, but now it refers literally
Yeah, I mean,
to
it seems like the
any place.
trial court got confused based on the change in the law, and, I mean, frankly, as I'm looking at all these jury instructions, I don't know how I could follow them as a juror,
No.
but that's what,
That's what they were given, and
Right.
really it was a mess. And if you go on to some of the other ones, I said that the lack of presumption of self-defense was the most egregious, but there's others that are right up there with it. There is the word "all" was used instead of just one, speaking to belief of who had to be harmed. Under the law, of course, Tiara only had to believe that one person was under threat of harm, not everybody all at once. So that's obviously a much higher burden that the jury is thinking about. And like you said, it's just, Judge Bergeron, it's impossible to follow the not guilty options. The jury was actually never even told of a not guilty option for self-defense. If the state failed to meet their burden, they were told that not guilty was an option if they didn't prove the elements of felonious assault, but they literally were not told that not guilty was an option if the state failed to prove self-defense.
Let me ask you this, Ms. Berry, just setting aside the failure to provide a definition of what a residence is, and also you indicated the failure to provide the jury with the instruction that there's a presumption of self-defense. I understand the state's obligation is to prove that your client proved beyond a reasonable doubt she did not act in self-defense. So I'm getting the question part. Does it matter that the judge did not instruct on the presumption? Because it's a rebuttable presumption, and apparently, even if the instructions were faulty, setting aside the residence issue, that they were substantially correct. So does it even matter that the judge didn't instruct on the presumption of self-defense?
Yeah, it's still absolutely crucial because you're talking about the jurors' starting point thoughts about the analysis. So if they had been given that presumption instruction, even though they were told that the state had to prove the elements of self-defense beyond a reasonable doubt, that she didn't act in self-defense beyond a reasonable doubt, it's still crucial that they have that instruction about the presumption, because that is where the jurors' starting point thoughts are about the case. If they had been told that, they would have thought Tiara did act in self-defense. She did have a reasonable belief that she was in imminent physical harm and that using this force is the only means of escape. Her level of force, even though it was a gun, deadly force, was presumed to be lawful. So those starting point presumptions are everything, especially in a case where the state is hitting on those points and saying she created the danger, she is the one that escalated it, she brought out a gun, she did all these things. Well, the juror's starting point would have been a presumption of lawfulness on her part, and I think that makes all the difference.
Okay, thank you.
and you're at your time.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, counsel. I guess the best place to start in any appeal is the court's standard of review in this, and I think it's clear from the transcript on page 774 that the state and the defendant agreed to the terms of the jury instructions that were finally given to the jury. I understand that there were discussions about other ones that, and specifically the definition of residence and the presumption of self-defense were discussed earlier, but I think it's incumbent upon the parties, and specifically defense counsel in this case, to ensure that that what was agreed to actually makes it to the final.
Right. Well, I mean, and I had concerns about that because normally I would expect to see like here's the jury instructions, and like that's not, we don't have a document that I've found in the record.
Right.
But with respect to the presumption, it's clear from the transcript that everybody, well, at least that's what the defense counsel was requesting. It's clear what they were requesting,
right.
And it's also clear that the judge agreed to that.
I think that's correct, Your Honor. And in terms of the Wallens case that Ms. Berry cited, I think the second part of that is that the requesting party has been unsuccessful in having the law included in the trial court's charge to the jury. And in this case, I don't think that the defense was unsuccessful. It just there wasn't the effort or to make sure that it finally made it into the final instructions.
Counsel, since we don't have the document, is it possible that this instruction was included in the document and then just not read out loud?
I guess it's possible, Your Honor, but when my reading of the transcript is that the court had the instructions written and she was reading it verbatim, the trial judge was reading it verbatim into the record. I don't see any indication, no indication from the parties, hey, wait a second, we talked about 290105B2 and that wasn't included. But I mean, that's a possibility, but I don't see any indication of that in the record.
So more likely that somehow between the conferencing and discussion and the preparation of the written instructions, this just got omitted.
That's certainly the way I look at it, correct. So I think it would be the state's position that we're left under those circumstances with a plain error standard of review. Under that standard, under Bailey case out of the Supreme Court has indicated that it must have affected the outcome of the trial. I think the cases that the state cites in its brief, Collins, Sims, Robinson, and Williams and Wilson from this case indicate that even when it's not a plain error standard, if there's evidence in the record indicating that the force was excessive or that there was not a reasonable apprehension of immediate physical harm, that the failure to give the presumption, the failure to give an instruction on self-defense as a whole, according to the Collins court.
Well, but I think here's the problem I have in terms of this case. And I've watched the video several times, so I understand how both sides presented that to the jury, but in light of what the video reveals, isn't that all the more reason why the defense would want the presumption? Because I can see the arguments, right?
Right.
But if I'm a juror and the presumption is she acted in self-defense, then I start looking at it through that lens. And maybe I'm not persuaded at the end of the day, maybe the state overcomes that. But compared to I get no instruction, so I'm just looking at it normally and I say, you know what, that's a close call, but I think the state's right about this.
Oh, I don't think there's any doubt that the instruction on presumption would have benefited the defendant. I think it's just a case of whether the failure to do so was plain error in this case. And when I was writing the brief, I looked at the video a number of times as well. And one couple of things about the video. One, these ring doorbell videos it's hazy, it's dark outside. You can't really see the perspective of what's going on behind Miss Robertson. So it's not a great way to look at the cases, the way I look at it. Don't believe everything you see, I guess is what I'm saying. But also there are gaps in the video that where it jumps around. So it's not, you can't tell where everybody is. You can't tell, you don't have a great idea of the sequencing of the events in the case. So when I wrote this brief, I specifically and I intentionally focused on the testimony of Corey Henry, who was a defense witness in this case, who was there. He was in the middle of the confrontation and what went on that day. And at trial transcript pages 640 to 681, Mr. Henry himself indicates that from his perspective, the melee was over when Miss Davis got her belongings back. It was his belief and his testimony that he was escorting Miss Davis to the car at that point, and at least one of the gunshots in this case came from behind, and it was Mr. Henry's testimony that Miss Robertson approached the victim from behind in this case. So I understand the power of the video testimony and especially with respect to the question of the presumption. But I think that when we have a defense witness who testifies as strongly in favor of the state as Mr. Henry did, I think that we can say that there was no plain error in the failure to give the instruction in this case.
Can you address the definition of residence?
Yes, Your Honor, and I think that's another thing that would probably the same analysis would pertain to what we were just talking about with the presumption. There was no, even though there was a discussion about giving the definitions, it didn't happen. It didn't make it into the final cut. I think, as Judge Bergeron indicated earlier, the definition of residence, there can be a certain terms of art about what that means. But in this case, the case was tried under the assumption that this carport was part of the residence. There was no argument saying, hey, wait a minute, this didn't happen inside the house. Or I don't remember it being emphasized anyway. Ms. Berry will certainly correct me if I'm wrong about this. There wasn't any indication to the jury that the four walls of the residence were the limits of the self-defense. So I understand that, and again, there was no doubt that this was an instruction that would have been beneficial to the defense. But again, I don't think it was plain error to omit that.
So do you concede that the carport area was in fact part of the residence?
I don't think there's any doubt statutorily, Your Honor. I really don't have a leg to stand on in contesting that. I see the problems with the jury instructions in this case. It would have been, of course, it'd been better if they had a flow chart kind of a thing where if X, then Y. But I think what we're instructed to do.
That's what the jury needs. They need a flow chart on this stuff.
Exactly.
It's very convoluted.
It is. But I think.
Obviously, that's the legislature's prerogative.
Yeah,
that's what they're
right.
doing.
And I think it's endemic to the statutory scheme itself. It's
Right.
not necessarily any error in what the trial court did. But I think the court's instructed to look at the instructions as a whole, and if they do so, I think that the court can conclude that there was no plain error in what occurred here. Unless the court has any questions, I'll just ask the court to affirm the decision of the trial court.
Great, thank you.
Thank you.
Ms. Berry, you have 3 minutes.
I just want to address a couple quick points. Just want to emphasize the state just noted that from the state's perspective, Corey gave testimony that was helpful to the state. I just urge the court to keep in mind that it's really Tierra's state of mind that's important. And I think the overall picture from Corey's testimony is that he makes it very clear that Anisha is not invited there. She is not welcome. The videos make that clear. And that's the biggest takeaway from Corey's testimony. But if Corey felt that the fight may have been de-escalating, it was Tierra's perspective that is the crucial one. It's Tierra's perspective that counts, and she's the one that has the history of domestic violence. She's the one that her wrist was already stitched open. She's the one that was sitting right next to Corey when he got nearly fatally stabbed 2 weeks prior. She's the one whose son was in the house. So it's really her perspective that's important. Additionally, I think everybody's in agreement that the carport was part of the residence. And even though that was not in dispute, that lack of definition of residence for the defense of residence and for it's needed to understand the presumption of self-defense, which of course we know is completely omitted. It's crucial for the jurors as well, because I'm sure they also watched those tapes a number of times. And in them, I believe it's video 2 at around minute 52, you have the police officer lecturing Tierra about why she didn't go in the house, why she took this upon herself. And, it's one of those things where without the jury being affirmatively told what residence is, they're going to take that officer's words with a lot of weight when there's nothing to combat it with. So I just urge the court to keep that in mind as well. And if there's no other questions, I believe that concludes my argument.
Great, thank you.
Thank you.
Thank you both for your arguments today. The case will be submitted and we'll get out a timely written decision. Hope you both have a great day.
Court of Appeals, First Court, District of Ohio is now adjourned.